Every single channel covering the Oswego DoorDash driver is telling you she's going to prison for 8 years. I need you to stop. She's not. The criminal court is the distraction. The civil court is the executioner. She thought she was the judge. She pointed that camera. She posted that video. She displayed his house number to thousands of strangers, and she walked away thinking she had won something. Here is what nobody is telling you. The 8 years, that's a ceiling she will never see. What is the real legal guillotine in this case? The one with a multi-million-dollar price tag attached to it? That is the only question that matters. And if you click away right now, you are going to miss the most financially devastating legal update in this entire case. If you are dealing with a false allegation right now, the confidential submission link is in the description below. Every document I'm about to show you is linked in the description. Hit subscribe so you never miss the documented truth. October 2025. Oswego, New York. A 23-year-old DoorDash delivery driver named Olivia Henderson walked up to a customer's front door. What happened next was documented, charged, and indicted by a grand jury. She didn't just make a delivery. She pushed open the door, she filmed an unconscious, unclothed man inside his own home, and then she posted that video to TikTok with his house number visible to a public audience. And then she fabricated a high-severity criminal allegation against him.
A man's world! I'm the victim!
A grand jury reviewed the evidence and returned an indictment on 2 felony counts. Count 1, unlawful surveillance in the second degree. New York Penal Law Section 250.45, a Class E felony. Count 2, dissemination of an unlawful surveillance image in the first degree. New York Penal Law Section 250.60. She was arrested. She entered a not guilty plea in December 2025. And as of early 2026, her case is currently navigating pre-trial transfer hearings. That is where the case stands. And that is exactly where every other channel stopped their research. The phrase 8 years in prison is being repeated on every platform right now. I want to show you exactly where that number comes from and why it is legally irrelevant to Olivia Henderson's situation. Unlawful surveillance in the second degree is a Class E felony, the lowest felony classification in New York State, nonviolent. The maximum sentence for a first felony conviction, 1 1/3 to 4 years. The dissemination charge, same classification, also nonviolent, also capped at 4 years for a first-time offender. 4 + 4, that's where 8 years comes from. Now here's what the documented sentencing reality says. Jail is not mandatory for a conviction on either of these charges. The actual options for a first-time offender include a split sentence, 6 months in jail, then 3 to 5 years of probation, a conditional discharge, or a straight probationary sentence with no jail time at all, no mandatory jail, no mandatory sex offender registration on the dissemination charge. Hold that thought, because in about 90 seconds, I'm going to show you exactly why her public defender wishes that criminal exposure was her biggest problem. Here is what everybody assumes. They assume the grand jury indictment is the end of the story. 2 felony charges, criminal court, whatever sentence the judge hands down. That's where it stops. That assumption is going to cost Olivia Henderson everything she will ever earn. Meet New York Civil Rights Law Section 52B, private right of action for unlawful dissemination or publication of an intimate image. I had to read Section 52B 3 times to make sure I wasn't misunderstanding the absolute financial ruin it allows. Because what this law permits a civil jury to do to the person who posted that video is extraordinary. This law has nothing to do with the criminal court. It does not require a conviction. It does not require a guilty plea. It does not require the criminal case to be resolved at all. The statute says it directly. Nothing in this section shall be read to require a prior criminal complaint, prosecution, or conviction to establish the elements of the cause of action. That man can file a civil lawsuit against Olivia Henderson tomorrow morning. While her criminal case is still in pre-trial hearings, the clock is already running, 3 years from the day she hit post.
So not only did I get assaulted 3 days ago on October 12th on Sunday, I then lost my job, the police are doing nothing, and if I get one more account strike on TikTok, my account's done!
Now let me show you what that civil lawsuit can actually demand. The statute authorizes a jury to award injunctive relief, punitive damages, compensatory damages, and attorney's fees. In plain English, injunctive relief means a court order forcing that video off every platform, every repost, every cached copy the court can reach. gone. Compensatory damages means every documented dollar of harm to his life, emotional distress, lost income, psychological treatment, the cost of what she did, line by line, receipt by receipt. And punitive damages, in plain English, the civil court has the power to take every dollar she makes for the rest of her life. There is no statutory cap on punitive damages under Section 52B, no ceiling, no limit. Whatever a jury decides she deserves to lose, she loses. And the court can order her to pay his legal team on top of all of it. She thought she was the judge. The real judge, sitting in a civil courtroom with a jury under Section 52B, is about to hand her a bill she cannot pay. Remember what I told you at the start about the 8 years in prison? Here is why her public defender actually wishes that was her biggest problem. Texas, August 2023. A woman sued her ex-boyfriend for distributing intimate images of her, posted to social media with her name, her address, and her face visible and identifiable. The jury awarded her $200 million for past and future mental anguish and $1 billion in punitive damages. $1.2 billion. Olivia Henderson posted a video to TikTok of an unconscious, unclothed man with his house number on screen. The fact pattern is not theoretical, it is documented. And that's not the only lane she's exposed in. Federal law passed as part of the Violence Against Women Reauthorization Act of 2022 creates a separate federal civil cause of action, a parallel claim, federal court, $150,000 in liquidated damages, on top of actual damages and on top of attorney's fees. That is the floor, the baseline minimum before a jury calculates a single dollar of real harm. She doesn't face one lawsuit, she faces two simultaneous legal lanes, state and federal, each carrying its own damage calculation, each with its own jury, each with its own judgment. And I haven't even told you what happens when you stack an intentional infliction of emotional distress claim on top of all of it.
A victim of SA by a DoorDash customer while I was doing my job as a DoorDash driver. The DoorDash customer requested that their order be left at their front door. When I arrived at their front door was wide open, their lights were on, and they were sleeping on the couch within eyesight of the front door with their pants and underwear pulled down to their ankles, and they were indecently exposed to me.
Here's what a 15-second TikTok post actually costs. Criminal exposure, 2 Class E felonies, first-time offender, documented sentencing pointing toward probation or a conditional discharge. Civil exposure under New York Civil Rights Law Section 52B, uncapped compensatory damages, uncapped punitive damages, mandatory attorney fees, a 3-year clock that started the day she hit post. And Section 52B, the law she never Googled, does not care about any of her excuses. It does not wait for a conviction. It does not require one. The grand jury indictment was the headline. Section 52B is the verdict she never saw coming. And I'll say this plainly because I think it needs to be said. If you pick up a camera, fabricate a criminal allegation against someone, post their identifying information to a public platform, and think the worst thing that can happen to you is a criminal sentence a judge will likely suspend, you have not read the law. You have not done what this channel does. You have not Googled what comes next. The system is not broken. In this case, it is working exactly as designed, and it is coming for every dollar she has. If you think she deserves everything Section 52B can deliver, say so below. If you think the civil system is overcorrecting, I want to hear that too, because this case is not over. And neither is this conversation. If you want to see what happens when someone tries to weaponize a false narrative for personal gain and how that story ended, I covered it in full in the documented truth about the Rossi ruling. Link is on screen right now. Coming up next, the financial document that people lie on more than any other piece of paper in the legal system, and the exact pattern courts are trained to find. That is the toxic pattern of a financial affidavit. It is already on screen. I'll see you in the next one.